Let's start 302 with the foundation, contract law. If you want to pass this course, you must understand the difference between an offer to purchase and a contract, and a broken contract, maybe. And that sounds simple, but students miss questions here because they use everyday language instead of legal language. An offer is not a contract. An offer is a promise by one party asking another party to accept it. A contract exists only when there is mutual assent. That acceptance occurs. You have to have legal capacity, lawful objective, and consideration. Now, for the test, let's focus on the big four for a minute. Mutual assent, consideration, capacity, and lawful objective. Mutual assent means offer and acceptance, that meeting of the minds. Consideration is what is bargained for. And in a real estate sales contract, the consideration is the purchase price paid in exchange for the deed, not the earnest money. Certainly not the due diligence fee. The consideration is the purchase price. Now, capacity matters because not everyone can legally bind themselves in the same way. Minors generally create voidable contracts, and a person who has been declared mentally incompetent by a court creates a void contract. That means no contract. Now, let's think about termination of offers. An offer can end when it's rejected. A counteroffer is a rejection. It can be revoked before acceptance. There could be a time limit for acceptance, death, or insanity of one of the parties, and destruction of the property will terminate an offer. And remember, a counteroffer kills the offer. It's not a little edit. It is a brand new offer. And you need to remember the mailbox rule. If acceptance is properly mailed to the right person, when it's mailed and dropped in the box, it is communicated, not when it's received. And another trap has everything to do with misrepresentation, duress, undue influence, and mistakes. These do not automatically mean the contract disappears. Many of these make the contract voidable by the injured party. Void and voidable are not the same. Void means no contract. Voidable means one party may have a legal right to avoid performance under the terms of the contract. Also, be familiar with the Statute of Frauds. Remember, agreements that convey an interest in the title to real property must be in writing to be enforceable. And don't forget that brokers never practice law. Brokers are allowed to fill in the blanks of pre-printed forms. Brokers do not draft custom legal language in North Carolina. And for the test, keep asking yourself, is this an offer or a contract? Has acceptance been communicated so that it's binding? Is the contract valid, void, or is it voidable? Was the broker filling in the blanks, or were they drafting? That is how you control this section on the exam for 302. My name's Kim Stotesbury, and I am here to help you pass that test.